So in this video, I have an important update for you on the Texas suppressor freedom case, which aims to stop the NFA and ATF's regulation of suppressors. So let's talk about what is happening. But real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like GOA and FPC. So if you want to get great coffee and support the 2A cause, I highly recommend you check out Blackout Coffee. You can find them using the links down below. And thank you again to Blackout Coffee for supporting this 2A content. So as I mentioned in the intro, in this video, we're going to be discussing the Texas suppressor freedom case, this lawsuit, which aims to eliminate the NFA and ATF's regulations of suppressors. The case we're going to be discussing in this video is called Paxton v. Dettelbach. This is an important and interesting case that was decided by a district court, a lower court, and this was decided on cross motions for summary judgment. In July, the federal district court, the lower court, issued an order granting the ATF's motion for summary judgment. What that means is that the case was dismissed by the lower court in its entirety because the court found that there was a lack of standing. So they agreed and sided with the ATF. In that decision, the lower court ruled that none of the individual plaintiffs have an injury in fact to actually meet the standing requirement. Also, the court found that the state of Texas cannot stand in the place of its residents to sue the government to stop the application of the NFA towards these made in Texas suppressors. Well, now the state of Texas and this Texas suppressor freedom case has been appealed to the pro-Second Amendment Fifth Circuit Court of Appeals. So now the higher court is going to review and decide this case. And the ATF has now submitted their briefs to the Fifth Circuit, and they argue that the Fifth Circuit should actually affirm that dismissal and in fact should not even hold oral arguments on this case at the appellate court level. In their brief, the ATF once again argues that suppressors are simply accessories and therefore not bearable arms protected by the Second Amendment at all. This argument results in the Fifth Circuit now being set up to address whether or not these items, like suppressors, are in fact protected by the Second Amendment, and if the plaintiffs here have a legitimate 2A claim that should have not been completely dismissed and thrown out by the lower court. Now, for those not aware, this lawsuit arises out of the Texas House Bill 957, which passed in prior years. HB 957 aimed to exempt from federal regulation all suppressors that are made in and also remain within the state. The claim behind this law is that since these items are made and sold exclusively within the state, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. Now, after Texas passed this law, the ATF sent out warning letters to all individuals, I believe all gun stores in Texas, saying that the ATF still believed that these items were regulated under the NFA, that they still had authority over these items, and therefore they would still enforce those regulations against any made in Texas suppressors. So once again, be very cautious with this. I do not recommend you guys deal with these items at all. Let this litigation pass because the ATF is still very much enforcing this law. Now, in response, Texas, along with individual plaintiffs, then filed a lawsuit against the ATF. This case was then submitted to a federal court, and on cross motions for summary judgment, the court there agreed with the ATF. The court ruled in favor of the government under the rationale that the plaintiffs lack standing to actually bring this lawsuit. Standing as a concept has three basic requirements. First, there must be a concrete injury in fact that is not conjectural or hypothetical. Second, there must be causation, which is a fairly traceable connection between a plaintiff's injury and the complaint of conduct of the defendant. And finally, third, there must be redressability, which is essentially that the relief that is being sought would actually cure that injury. The judge stated in his opinion that individual plaintiffs are correct that the government has a history of prosecuting the illegal possession of unregistered silencers. But these plaintiffs have adduced no evidence that they in fact possess any illegal silencers or otherwise attempted any prohibited conduct, nor have they shown that they have been threatened with prosecution or that it is likely. And the doctrine of criminal law forbids convicting persons for mere thoughts, desires, or motives. Individual plaintiffs therefore failed to allege a substantial risk of prosecution based solely on the desire to do something the government has prosecuted in the past. He goes on to state that individual plaintiffs' fear of prosecution is imaginary or speculative at best and insufficient for Article 3 standing. Now here, the judge essentially is stating that the individual plaintiffs would have to allege that they possess an illegal silencer, maybe one of these made in Texas suppressors that they made in violation of the NFA, or that they have engaged in some other prohibited conduct that the ATF claims is illegal. The court also claims that the plaintiffs could show standing through evidence that maybe they did something directly, went through the process, or maybe even that they were directly threatened by the ATF. In essence, the judge requires a person or a plaintiff here to subject themselves to the unconstitutional process or do something illegal before they actually have standing to bring a challenge to the ATF. Finally, the lower court also found that the state of Texas did not have standing to sue on behalf of their residents. And based on all of that, the judge granted the ATF and the government's motion for summary judgment and dismissed the case in favor of the ATF. Now, in response, Texas asked the Fifth Circuit Court of Appeals to review this case. They filed an appeal, and ultimately they asked the Fifth Circuit to also reverse the lower court's decision. Now, in their brief to the Fifth Circuit, the state of Texas argues that this case warrants oral argument because it raises issues of exceptional constitutional importance. Do Texans have standing to challenge the constitutionality of those statutory requirements before applying for permission and paying the tax? And does Texas also have standing to vindicate its quasi-sovereign interest in its citizens' health and safety? Well, now the ATF has responded and is arguing to the Fifth Circuit Court of Appeals that they should affirm the lower court's dismissal, and in fact that the Fifth Circuit should not even hold oral arguments in this case. And two of the main arguments that the ATF puts forward in their brief is that not only are they arguing that the process to do the NFA requirements, the registration, the taxation, all that, they argue that it is very fast and therefore it would have been more efficient to just go through the process than file a lawsuit. But they also claim that firearm suppressors are not protected by the Second Amendment at all. The ATF argues in the brief that the mere invocation of a constitutional right cannot substitute for the presence of an imminent, non-speculative, irreparable injury. Rather, that showing may only be made where the impairment of a constitutional right inflicts an immediate, insufficient, real-world injury. Here, plaintiffs failed to demonstrate any such injury. The NFA requirements indisputably do not prevent plaintiffs from making and using silencers, and plaintiffs have identified no immediate and significant real-world injury that would occasion it requiring them to comply with the NFA's procedures. In this section, the ATF argues that the process to register the items is not so burdensome enough that it creates a required injury in fact. Now, also interestingly, later in this section, the ATF also claims that the average registration processing time and approval time is only about 70 days or less. However, I know plenty of people that are actually experiencing times that are way beyond this claimed 70-day process. The ATF also argues that the plaintiffs cannot claim that the time wait in that period is an injury on its own, basis, because they say that filing this lawsuit took longer than just going through the process. And it's actually interesting, and it's a weird defense when they point out the fact that litigating over fundamental rights takes so much longer than just going through the unconstitutional process that they want to challenge. Then the ATF goes on to argue, of course, that the Second Amendment is not implicated at all when it comes to suppressors. In this section, the ATF states that the Second Amendment's protection extends only to instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections. And a silencer is a firearm accessory, it's not a weapon in itself. So the ATF continues to double down on their position that suppressors are just accessories and not bearable arms, and therefore they're not afforded protections at all under the Second Amendment. That, of course, directly runs contrary to the ATF and the NFA's actual regulation of the items as actual firearms in their own right, but the ATF continues to argue that despite the federal laws, these items are not firearms or bearable arms. Instead, they're just accessories that the ATF can regulate however they want. Now, what's also interesting about this is the ATF is completely ignoring Bruin. They're ignoring the text as informed by history and tradition analysis. They do not put forward any historical evidence to support this government restriction. So this is definitely an important case and an important appeal going forward. But hopefully the Fifth Circuit gives us another pro to a win. They've been very favorable when it comes to the ATF's overreach recently. And in fact, the Supreme Court is going to be hearing arguments on the Cargill bump stock lawsuit soon and coming up this year. So hopefully there's a lot of things that move forward. And one of the other big wins we get here in 2024 is this Texas suppressor freedom case. Now, of course, if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of toy news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.